Welcome back. We are now on the record, and apologies for the slightly late start. The first docketed item for today's hearing is docket number 2022-020, clause number 076-03, in the matter of the notice of agency action requesting the board issue an order requiring the operator of record plug the Lavinia ST 1-32 well. I'll now ask for appearance of counsel.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Mr. Gruelle, please proceed. I'll give you the time.
Perfect. Chairman Borden and the rest of the board, the division is here seeking to have an order forfeiting the bond covering the Lavinia ST 1-32 well, which I'll likely refer to as the subject well. The board has regulatory authority in this case under Utah Admin Code R649-3-36 and Utah Admin Code R649-3-1.16. The division also requests an order concerning the costs that the division will likely incur in plugging the subject well, and there is regulatory authority for such an order pursuant to Utah Admin Code R649-3-1.16.5. Just to give you a little bit of background, I'd like to have Josh Payne with the division give some of the relevant information, but before he does that, I'd like to have him sworn in as a fact witness.
Do you want to swear Dustin too, just in case on the technical side? Do that if we need him.
We'll do that if we need him.
Will you raise your right hand, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Payne, let's go through some of the details surrounding the subject well. Do you know when it went out of operation, when it stopped producing, roughly?
Yeah, last production would have been in 2016 timeframe.
And have you been in communication with Regal, the operator of this well, since that time or leading up to that time?
Yes, myself and other staff with the division have been in contact with Regal during that time.
Do you happen to know if the division ever issued an order telling Regal that they needed to plug and abandon the well?
Yes, that order had been issued.
Can you tell me when that order occurred?
Do you want to know like the division enforcement order? The first one is that?
Yeah.
Yeah, I'm sorry, just give me a second. I got to pull the date. Okay, the division enforcement order that ordered the well to be plugged was issued October 27th of 2021.
Perfect. And were there any other orders issued during that time?
After the division enforcement order goes out and it's not responded to, a final penalty assessment order goes out, and that was issued in June 2nd of 2022.
And did that June final assessment also indicate that Regal needed to plug and abandon the well?
It did. So just some background on the final penalty assessment order. It reiterates the division enforcement order and then also states the final penalty assessment that is due at that time.
So if I'm understanding correctly, the subject well went out of production in 2016, and then we have orders in 2021 and 2022 respectively, telling Regal, the operator, to plug and abandon the well. Is that a correct assessment?
That's correct.
Thank you. So this is just an abbreviated timeline that I put together that illustrates what we've just gone through. Roughly May of 2016 is when the subject well went out of production. The division has issued several notices and orders, including in June of 2022. Under Utah Admin Code R649-3-36, there's a 5-year period of activity or non-productivity. If that occurs, if there's that 5-year time period of non-productivity followed by a division order telling an operator to plug or bring into production the well, then the operator will forfeit the drilling and reclamation bond, and the well will be properly plugged by the division. This well has been shut in or temporarily abandoned since roughly May of 2016, as evidenced by Exhibit E, which was filed before the hearing, as well as Mr. Payne's testimony. The division has ordered Regal to submit sundry notices, and Regal has not plugged those wells, and that's exhibited by the exhibits filed as well as Mr. Payne's testimony. So there's authority under this section of the regulation to give the division what it's asking, which is to have the well orphaned and a direction to plug. There's also regulatory authority under Utah Admin Code R649-3-1.6, where it says the division shall take action to forfeit the bond if the operator refuses or is unable to conduct plugging and the site restoration. In this instance, that's pretty clear based off of a letter submitted by Regal to the division, which has been included as Exhibit H in the filing. It's also clear just based off of Mr. Payne's testimony where the division has ordered plugging and no plugging has occurred, that either the operator is refusing or is unable to do so. So after proper notice and hearing, the board may order the division to use funds collected from the bond forfeiture to complete the plugging and restoration operations. And that's what we're asking for here today in the amended notice of agency action. There's likely going to be deficient bonding. Utah Admin Code R649-3-1.16.5 says, in the event the amount forfeited is insufficient to pay for the full costs of the plugging and restoration, the division may complete or authorize completion of plugging and restoration and may recover from the operator any costs of plugging and restoration in excess of the amount forfeited. Mr. Payne, do you happen to know what the bond in place is?
I do. The well currently has a bond of $15,000.
And do you happen to know what the best estimate is for the cost of plugging this well?
An estimate that we received from one of the plugging operators out in the field was $130,048.
Those numbers are corroborated by the exhibits which were filed before this hearing. So there's likely going to be a dramatic deficiency in the bond amount in order to plug this well. So what the division is asking for in their revised or amended notice of agency action is for an order forfeiting Regal's bond in accordance with Utah Admin Code R649-3-36 and Utah Admin Code R649-3-1.16. Also, that the board's order orders the operator to pay the difference between the bond amount and the actual cost of the subject well pursuant to Utah Admin Code R649-3-1.16.5. That concludes the division's presentation in chief. Before we move on to hearing from Mr. Rett and Ms. Underdahl, does the board have any questions for the division?
Mr. Moon?
So is Regal the original driller of the well? And if not, when did they take over? Or when was it originally drilled and when did they take over as operator? Just to estimate, I don't need exact. Just
So Regal is not the original operator of the well. It was drilled by Mission, I believe, and I apologize. I didn't. Ed or Marcy might be better, I guess, to say when they took over the well. I don't have that information with me, and I apologize.
okay. We'll probably gather that up.
Any other questions from the board? I have a quick question. Exhibits A, B, and C, we're referring to events from 2014. Did you discuss that with us?
No, those were originally filed with the original notice of agency action, which substantively was requesting different relief than the notice of agency action as amended. And so those particular exhibits are not as relevant to the current discussion.
Okay. Does that complete the divisions?
Presentation in chief. It does. Before we hear from Ms. Underdahl and Mr. Rett, I would like to point out that under R641-102, subparagraphs 100 and 200, natural persons are able to appear on their own behalf. However, corporations must be represented by an attorney. In this instance, the notice of agency action has been amended. The original notice of agency action did include relief requested against those individuals in their personal capacity, and therefore it would have been appropriate for them to appear at that time. However, since amending the notice of agency action, we are only seeking relief against Regal, a corporation, and therefore, under the rule, it's inappropriate to have these persons represent the corporation. The board has the authority to waive that rule, and the division would be supportive of that, provided that both individuals go under oath and the division has a chance to ask a few questions to ensure that they have an understanding of Regal's actions and can speak to the facts of Regal concerning this issue.
Thank you, and that seems reasonable on your part. So I think I'm comfortable to proceed with those conditions.
Perfect. So let's go ahead and have Mr. Rett and Ms. Underdahl go under oath.
First, I'd like to thank the board for hearing this. Sorry. First, I'd like to thank the board for hearing this and for the work you do in natural resources. It's really important to our entire state. Secondly, I would like a little bit of clarification. The letters have been sent to me, not to Regal. Regal is a corporation that no longer exists. The only valid asset that it really has right now is the $15,000 bond that was returned by the state of Utah.
Sir, could perhaps you should go under oath before we start getting into any details?
Well, I have no reason to testify. If you're going after Regal, you can do whatever you want to them. I have no
Okay,
reason to be here.
In that case,
Because these letters were directed to me and Ms. Underdahl. You can't have it both ways.
all right, we're proceeding against the entity, not yourselves as individuals, so you shouldn't be speaking. Is that what you?
Can't speak for the corporation. He just said that. And the corporation doesn't exist anymore, so I doubt anybody will be speaking for it.
I don't know if you understood what the division's position. The division's position is that rule can be waived and you can speak. You just need to go under oath.
I have no reason to speak if you want to go after Regal. It has no valid assets worthwhile. You can make any finding against Regal you want.
So are you unwilling to go under oath to say that? Is there a reason you're uncomfortable with being under oath for these statements?
I'm not uncomfortable for being under oath, but I have no reason to be under oath if you're going after a corporation that no longer exists.
Okay.
That's simple common sense.
In that case, the division would like to move for a default against Regal if Mr. Rett and Ms. Underdahl are uncomfortable going under oath to speak to Regal's actions.
Well, I don't believe the two of you should be speaking if you're not representing the corporation, the company. So you need not speak.
You want me to clear up something?
No, I don't want you to do anything.
Okay. I'll entertain a motion for granting a default.
I move that we obtain a default.
Against Regal. Against Regal.
Okay, I make a motion that we obtain a default against the Corporation Regal.
All in favor, say aye.
Aye.
That was unanimous.
Chairman Borden, with your permission, the division would like to draft a proposed order that we'll submit to your council in the coming weeks.
Yes, please proceed.
Perfect. I believe that concludes this matter unless the board has any other questions.
Seeing none, thank you.
Gentlemen, could I thank you very much for your time?
Could I add something?
The division would request that anything added be made under oath.
You're opening yourself up to be questioned under oath. Stop it.
I think there's no opportunity for public comment on this. Thank you. We'll move on to the next docketed item. Number 2. Docket number 2022-021, clause number 131-157. The matter of the request for agency action of Berry Petroleum Company, LLC, for an order declaring that the board's findings of fact, conclusions of law, and order granting approval of unit operations and enhanced recovery for the certification of an enhanced recovery project in clause number 214-2 does not prohibit the drilling, completion, recompletion, and deepening of wells below the lower Green River Formation in the Antelope Creek unit embracing portions of townships 4 and 5 south, ranges 3 and 4 west, USM, Duchesne County, Utah. I'd now ask for appearance of counsel.
Trevor Guel with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Angela Franklin of Holland and Hart on behalf of the petitioner, Berry Petroleum Company, LLC.
I'd give the floor to Berry Petroleum.
With your permission, I'd actually like to take lead on this, if that's okay.
Oh, sorry. My apologies.
No apology necessary, Chairman Borden. This matter came before the board in the October hearing, and at that time, Berry Petroleum and the division were able to work out an agreement that would allow Berry to continue with their requested action. And since that time, Berry and the division have worked diligently to come to an agreed-upon stipulation that memorialized the terms that was agreed upon during the October hearing. We have filed that just before this hearing began, so the board has not had a chance to review that stipulation, but with the board's permission, if after reviewing the stipulation, the board should accept the proposed order attached to that stipulation as drafted, unless there are any issues. And just as a reminder, the substance of the request was to go in and recomplete as well as drill new wells into 2 different formations. the reason that the division had some heartburn surrounding that request was that there's a secondary enhanced recovery project with a board order in place governing that secondary enhanced recovery project. So it wasn't clear to the division that the division could administratively authorize those APDs that would be recompleting or completing into the two formations, given that board order. However, the agreement that the division has reached with Barry is that a half-mile buffer will be in place, which will ideally separate any activity or communication between the two wells. And given that agreement, the division is comfortable moving forward, provided that the board is also comfortable moving forward, given that this would in some ways affect the subject order in
All
place.
right, we'll read the document with interest. Okay, back to Berry Petroleum.
Thank you. I have with me today representatives with Barry, Connie Conks, who's the senior staff landman, and Manik Singh, who is a senior reservoir engineer, in case the board has any questions. If so, we can swear them in, but we are available for any questions.
Before we proceed, I think given this has just dropped into our laps so recently, I'd like the board to step out for a deliberation to talk about this change.
I think that's perfectly appropriate.
Thank you.
Okay, we are off the record. We will reconvene as rapidly as we can. We are back on the record. And I'm sorry I cut you off. If Berry Petroleum has anything to say, please proceed.
No, you didn't cut me off. We are good, and we're just here in case there were any questions.
Okay, thank you very much. Division, anything else on your part?
Not unless the board has any questions.
Yes, actually, Mr. Moon.
So this is all of this order pertains to tribal leases, is that correct?
Wait, there's, correct. Well, there's two, I'm struggling, I don't have my map in front of me. There's something in 4.3 that, it's tribal minerals, I'm sorry.
Okay. And is there, and these leases are held, and any issues with depth where you're going deeper? Are there depth clauses where you could not have a right to drill, anything like that?
There's only one lease where we depth severed. I think it's from the base to the Wasatch, but other than that, we have all depths.
Okay, so you're taking that into account
Yes,
in
sir,
your
we are.
plans? Okay, thank you.
Any other questions? I believe a motion then is in order to approve the proposed order, which we all just reviewed, and I will entertain a motion.
So I would move to approve this request for agency action.
Let's vote on that. All in favor say aye.
Aye.
Let the record show that was unanimous. Thank you for your time.
And Chairman Borden, I just want to say thank you to the board for your patience with this coming in kind of at the last minute. Division and Barry have been working really hard. We're really glad that this project can move forward, and thank you again for allowing this.
I think the board always likes things to be worked out between all parties to something that's mutually agreeable and beneficial. So thank you.
Thank you.
The next docketed item on the agenda, docket number 2022-23, cause number S0230094 has been dismissed, so we can move on from that one. Which brings us to item number 4, docket number 2022-025, clause number 132-06, in the matter of the request for agency action of Ovintiv USA, Inc. for an order vacating the order entered in cause number 139-99 and instead pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the new two Veep wells, apologies, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River formations, comprised of all sections 16 and 17. I'll now ask for appearance of counsel.
Hi, Elizabeth Harris for the division.
And Mitch Mayo of Lear & Lear. I'm here. I have nothing to do with this matter, but I'm here witnessing and shepherding it through to the extent possible on behalf of Fred McDonald, who's not available today.
Okay, thank you. I don't know how to respond to that either. Everything is new and interesting today. Is that okay?
Yes, absolutely.
Okay, thanks. I guess it goes. The time goes to the division.
We'll try to make this very boring and easy.
Thank you. I'd appreciate that.
Good morning, Chairman Borden and members of the board. My name is John Rogers, and I'm an environmental manager with the Division Oil, Gas, and Mining. And I've appointed by this board to act as a hearing examiner in the matter of docket number 2022-025, cause number 132-06. In the matter, the request for agency action of Ovintiv USA for an order vacating The order entered in cause number 139-99 and instead pooling all interests, including the compulsory pooling of interests of certain non-consenting owners in the new 2V wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all sections 16 and 21, Township 3 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. This matter came before me as a hearing examiner on Wednesday, November 30th, 2022. The anchor location was the DNR building in Salt Lake City, and the two witnesses for Inventive were Mr. Peter Burns, a senior land negotiator, and Mr. Kendall Brown, a manager of the Uinta Reservoir. Both testified virtually. Both were recognized as expert witnesses by me in their respective fields of petroleum land management and petroleum engineering. The division had no objection to their recognition of experts in this matter. Their counsel was Mr. Fred McDonald, which we've talked about earlier, who presented in person. The division was represented by Mr. Trevor Gruwell of the Utah Attorney General's Office. My counsel was Elizabeth Harris, also the Utah Attorney General's Office. I wish to thank the petitioners, division staff, Attorney General's Office, and the department's technical staff for preparing for this hearing. The division filed a response on November 15, 2022 to Inventive's request for agency action in this cause, expressing no objection to the request for agency action, but they wanted Inventive to address legal precedent and applicable regulations concerning how they determine the risk compensation, how it should be determined. Inventive presented detailed analysis for the risk compensation of 300%. In my opinion, Inventive sustained its burden of proof and demonstrated good cause and sustained all legal requirements for granting the request for agency action. They provided an opportunity to participate to the non-consenting owners who did not timely respond and will be compulsory pooled into 8 new 2V wells outlined in their request for agency action. The order 139-99 shall be vacated and instead pulling all interest in the drilling unit established by the board order entered in July 21st, 2015 in cause number 139-134. The non-consenting owner shall have a risk compensation of 300%. The testimony and evidence was sufficient for me to accept this amount. The non-consenting owner shall receive an average weighted landowner's royalty of 16.444643%. Based upon the request for agency action, testimony, and evidence submitted, the findings of fact and conclusion of law, is my recommendation that the board accept the request for agency action as presented. And Liz, you have some issues concerning this.
Yes, I apologize that we had not submitted the proposed recommended order in advance. We were finalizing a couple things, but I do have that, and with your permission, I can approach and give that to your counsel.
Please proceed.
And just to confirm, the division has reviewed that proposed order and had no objection. That is the hearing officer's recommended order for the board's consideration.
Realizing you just received that, you probably have numerous questions or may want to review that. If you have anything at this time, we would take those, listen to those, or if you would, I guess I can assume sign this later as they review it.
I mean, yeah, whenever they feel comfortable to vote.
Let's move first to Mr. Mayo before we see if the board has any questions. Do you have any questions?
No questions. This was prepared by Mr. McDonald after the hearing. Again, I wasn't there, but we've gotten confirmation that Inventive has approved, Mr. McDonald has approved, the division has approved, and the division council has approved.
Board, any questions of the division? No, I believe, given we just got this in our hands again, we do need to step out briefly to deliberate this issue. So I would like to go off the record one more time, and we will be back as soon as we can. Thank you. And we are also back on the record. In our deliberations, I believe some additional questions came up, and does anyone from the board want to? Mr. Moon?
Yeah, I thought the division asked a good question about the risk compensation reward. The riskiness of having a dry hole in the basin is almost nil. Now, there's many other risks with drilling, but what convinced you that 300% was the correct risk compensation award versus something lower?
Well, they addressed, the first issue was this is the first, what they call cube development that will have wells that close. And so there may be a possibility of communication reducing production. I don't think we're worried about a dry hole. That's not the issue. The other issue was mechanical issues while drilling. There's a lot of clay intervals, and as they move through the horizontal, sometimes they've had some issues and they've lost 2 well bores and had to sidetrack on those. And given that history has been 300% has sort of been the average, we've never gone higher, but that seemed about reasonable what we've done in the past.
Okay, thank you.
Division, any final statements or comments?
No, I think based on the presentation at the hearing, it appeared that the Oventive did meet their burden of proof, and the division is satisfied that this should be entered.
Mr. Mayo, any final statements or comments?
Well, just one comment about the question, because it's something I think we've all been grappling with as batch development begins, but not specific to this hearing. Again, I wasn't there, and I'm not sure what was said as request. But I would also think about risk in kind of multi-dimensions, right? There's whether there's a dry hole, initial risk. Back in the day with vertical wells, maybe $1 million or $2 million at risk, and there's a different dimension to that risk these companies are undertaking now, and that's with the operatorship rules and the conglomeration, we've got, in this case, probably $80 to $90 million in capital that's being risked for these wells. And so the risk isn't always the risk that you're not going to produce. There is a capital risk, and a pretty significant one that goes into this batch drilling. So as the board starts to grapple with what an appropriate risk compensation award is, it's kind of important to remember that the risk has lots of different layers to it. That's my only comment.
Thank you.
I guess I would entertain a motion.
All right, I'd like to make a motion then that we accept the hearing officer's recommendation on this request for agency action.
I'll second that.
All in favor, say aye.
Aye.
Aye. Let the record show that was unanimous. I am now dating and signing this document. And thank you all for your time. Which brings us to the 5th docketed item. Docket number 2022-026, cause number 130-14, in the matter of the request for agency action of Oventive USA, Inc. for an Order 1, partially or wholly vacating the board's orders entered in cause number 266-01 and 266-02, and 2, instead extending the board's order in cause number 139-150 and partially extending the board's order in cause number 600-03 to establish special stand-up drilling units for the production of oil, gas, and associated hydrocarbons from the lower Green River formations of various sections. And I will now call for appearance of counsel.
Mitch Mayo of Lear & Lear, PLLC, co-counsel with Fred McDonald, again, who is unavailable to attend today, representing Oventive in this matter.
And Elizabeth Harris with the Attorney General's Office, representing the Division of Oil, Gas, and Mining. Thank you.
Mr. Mayo, I yield the floor to you.
Thank you, Mr. Chairman, members of the board. Appreciate you being here today. I don't see that I'm presenting yet, so give me one moment to make sure I handle this correctly. Oh, there we go. Perfect. Thank you for that. Mr. Chairman, members of the board, again, Mitch Mayo here on behalf of Oventive today. With me today, and I can't see them, and I've been texting but have limited reception. I'm not sure if I can just confirm that the witnesses are on screen. I can't see.
Oventive's here. Y'all see us?
Oh, there you go. I can see you guys now. Perfect. With me today are Mr. Jordan Lair. If you could raise your hand, Jordan.
We're not
We
seeing.
can't see them yet.
Oh, okay. Thank you. I've got one screen showing them and one screen not.
Okay, we can see them.
Perfect. Thanks, Mr. Chairman. With me today are Mr. Jordan Lair. If you raise your hand for me. He's a senior land negotiator with Oventive. Josh Reamer, also raise your hand. Thank you. And Mr. Kendall Brown. He'll be doing the reservoir testimony today. I'd like to ask the witnesses be sworn in at this time.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you hear the witnesses okay, Mr. Chairman?
Could you say something over there?
Can you hear this? This is Oventive speaking.
That works for us. Yep. Thanks, guys. The resumes of all three witnesses were submitted collectively as part of Exhibit A. If separately asked, each would verify the contents of their resumes as true and accurate. Mr. Lair will be a fact witness only today in land issues. Mr. Reamer has previously been recognized as an expert in geology on several occasions by this board. And Mr. Brown similarly has been recognized as an expert in reservoir engineering, most recently in cause 130-09, I believe. Based on their resumes and previous recognition by this board, and presuming the division has no objections, we request they again be recognized as experts for purposes of this cause in their respective fields.
Division, any objections?
The division has no objection to recognizing these experts. Thank you.
Board, any concerns or objections? Seeing none, the witnesses are recognized as expert witnesses.
Thank you. I'll remind the board when we present each witness. I'd also like to confirm before I begin that as is standard practice, that it's acceptable to move for admission of all the exhibits at the end of our case in chief. I assume that's still.
Yes.
Thank you. Today, Oventive is here before you seeking a partial vacation of the board's orders in 26601 and 26602. They're also seeking an extension of the board's order in cause number 139-150 and a partial extension of the board's order in cause number 600-03. All of these modifications to existing orders will be for the purpose of establishing three slightly larger than 1,280 acre long lateral horizontal drilling and spacing units for production from the Lower Green River Wasatch Formation. And it will be seeking, with these drilling units, lateral setbacks of 560 feet east-west and heel-toe setbacks of 100 feet to the north and 330 feet to the south. True and correct copies of the board's orders in all these causes, 139-150, 26601, 26602, and 600-03 were collectively submitted as Exhibit B in this cause. As has been done in previous Oventive causes, including 139-150, 600-02, and 600-03, Oventive requests the board to take administrative notice of the testimony of Mr. Mike Jensen and the exhibits admitted into evidence in the 139-134 hearing pertaining to the concept of drilling unit conversion and how correlative rights are in existing wells remain protected thereby. Obviously, this request is pursuant to Utah Code 63G-4-206 1B4. Similar to the 139-150 order, Oventive does not seek overlapping drilling units in this request. Rather, Oventive requests that production from existing vertical, directional, and short lateral horizontal wells, as existing, remain on a wellbore basis until the first long lateral horizontal well is drilled. And then, effective as of the first of the month following the date of first production, providing that production from all the wells will be allocated on the 1,280 acre basis, or in this case, on the acreage basis allocated to each specific drilling unit if larger than 1,280 acres. This method of conversion to 1,280 acre to long lateral horizontal allocation will prevent premature and unnecessary modification of existing rights to production until such time as the drilling of the first long lateral horizontal well. Also, similar to the 139-150 order, Oventive is here seeking today the authorization to drill up to 40 long lateral horizontal wells and a maximum of 8 vertical, directional, or short lateral horizontal wells per drilling unit to the extent 8 or more such wells already exist in a particular drilling unit to prohibit any further such new wells. There is a potential that in one of these slightly larger 1,280 acre units that there's 9 existing vertical wells, and Oventive would say declare them at legal locations to be legal wells, but that's the last of the short lateral vertical wells. This approach, more long laterals than short and verticals, will ensure maximum recovery of resource from each drilling unit. Furthermore, because of the Uinta Special Meridian line and the Salt Lake Basin Meridian line, there are 4 sections subject to this request that are partial sections. Sections 25 and 36 in Township 4 South 3 West, and sections 29 and 30 in Township 4 South 2 West. are partial sections, and the adjacent lands to the south are within the Greater Monument View super unit, as it's sometimes referred to. Without inclusion in the requested DSUs today, it is probable that these partial sections will be orphaned and not developed with horizontal drilling. As evidenced by the 130-09 order, inclusion of similar partial sections, including the subject drilling unit comprised of sections 16, 21, and 28, has been previously recognized and ordered by the board. Since Indian mineral lands are involved in these lands, this entry of the spacing order will also assist with the preparation and finalization of a communitization agreement. A valid spacing order is, whether through rule or agency practice, a requisite for entering into those agreements. As to the request for reduced north heel toe setbacks, Oventive's exhibits and testimony provided today will establish that this reduction in setback will, one, allow for recovery of additional 28 acres of resource. Two, will not adversely affect the correlative rights of the owner, of the owners in the adjacent drilling units, because there will be at least a 200-foot buffer, 100 feet on each side of the section line, protecting those drainage concerns. The board has jurisdiction over this matter pursuant to Utah Code 40-6-53B and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested DSUs, to the working interest owners, including unleased owners in the established drilling units, or, if unspaced, the quarter-quarter sections adjacent to the attached acres, due to the requested setbacks, and to the BIA and BLM being the governmental agency having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses disclosed by relevant BIA, BLM, and Duchesne County Realty records. Some were returned as undeliverable. The record will reflect notice was also duly published in the Salt Lake Tribune on November 13th, the Uinta Basin Standard on November 16th, and the Deseret News on November 18th of 2022. On November 23rd, Uinta Wax LLC filed a formal protest letter in this cause. However, the parties have since met and resolved that protest, and that protest has actually been formally withdrawn as of, I believe, Friday the 2nd, December 2nd, 2022. The division elected not to file a staff memorandum in this cause, and no other objections or responses were received. With that, if there are no questions, I'll proceed with my first witness.
If you'll allow us to interrupt just briefly,
Sure.
Mr. Moon needs to make a statement.
So I just need to disclose that my family has an interest in this request, and so I'll be participating, but I won't be voting.
Okay. Thank you for that.
Are there any objections to that arrangement with Mr. Moon?
No objections.
Yeah, none from me, but if you don't mind checking with my client, since they're remote. Actually, they're standing there. Do you guys feel comfortable answering that on the record, or do you want to go offline for a second?
No, we're good. No objections from Oventive on that.
Okay. We're good. Thank you for that.
Okay, thank you. Seeing none, please proceed, Mr. Mayo.
Thank you. My first witness, I'd like to call Mr. Jordan Lair. Jordan, again, raise your hand, identify yourself for the record. Would you please state your name and business address for the record?
My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay. And if you wouldn't mind, sometimes it helps the court reporter if you spell your last name and your first name.
Sure. So my first name is Jordon, Jordan, and my last name is Lair, Lehr.
Thank you for that. And would you please state your position with Oventive?
Yes, I'm a senior land negotiator with responsibilities over the lands at issue and related land records.
Okay. And if you could provide the corporate and bonding status for Oventive as well.
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for the Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of Oventive Production Incorporated.
Thank you. Now I'd like to show you what we've marked and submitted as Exhibit C through H. I'm going to flip through those. If you can take a look at those for me. Exhibit C, D, E, F, G, and H. Do you recognize these exhibits, Mr. Lair?
I do.
And were they prepared by you or under your direction or supervision?
They were.
Okay. Let's go back and start with Exhibit C. Oh, pushed the wrong button. Exhibit C. Can you see that all right on your screen?
I can.
Okay. Please help orient the board as to what they're looking at and where the requested DSUs are in location to relevant landmarks.
Sure. So Exhibit C is what we refer to as a regional locator plat, showing the 3 requested DSUs in red. As the plat shows, they are south of Highway 40 and southwest of Mighton, and directly bounded to the south by Greater Monument Butte Unit.
Perfect. Thank you for that. I was trying to find out how to use my pointer at the same time so I could direct, so I apologize. There we go. Exhibit D. Again, if
This
you would...
is just a...
Oh, go ahead. Sorry.
Sorry. Yeah, this is just obviously a zoomed in plat of the 3 DSUs that we're discussing here.
Okay. And what is the
main point of this?
Yeah, go ahead.
The main point of the slide is to depict the existing wells within the lands at issue, the details of which are reflected on Exhibit 1 to the request.
Okay. In Exhibit 1 to the request that you just referenced, and in the request itself, you identify that Oventive operates each of the wells identified within the requested DSUs, save 2. Can you confirm on the record that you provided notice, requisite notice, to the operator of those other 2 wells?
Yes, we did.
Okay. Have you received any response from the operator?
We have not.
Okay. Thank you. Turning back to Exhibit D, have all the wells within the requested DSUs, all of these dots within the red hatched areas, have they all reached payout under their respective well costs?
All of them but 2 have achieved payout, and only one owner, Lawrence Scott Noble, is still in recoupment status pursuant to the terms of the board's compulsory pooling order entered in cause number 26602.
Okay. And how does Oventive plan to deal with the recoupment still owing it under Mr. Noble's compulsory pooled interest?
Oventive has agreed in the request to waive any further recoupment as to the remaining wells, thereby providing for a clean slate, so to speak, on a go-forward basis. And none of the other consenting owners benefiting from the non-consents have expressed any objections. This will help facilitate the requested 1,280 acre, as we've discussed, plus or minus DSUs with minimal complications.
Okay. Thank you with that. And you know, I do the same thing. I keep calling them 1,280 acre. I think we're all used to that. I think we'll understand if you misspeak and know what you mean. I'll try and start referring to them as long lateral DSUs. So let me recap your testimony to the extent it got lost. Oventive is simply going to waive any recoupment left under the 26602 order.
That's correct.
Okay. And the board has already taken administrative notice of the testimony of Mr. Jensen regarding conversion generally, as expressed at the hearing in cause number 139-134. But can you please discuss the timing on conversion, if approved, from Oventive's standpoint?
Sure. So for existing vertical and short lateral wells, the conversion's effective as of the first of the month following the date of first production of the first long lateral drilled, and will be effective as of the date of first production for the long lateral well drilled.
Okay. So to immediately upon entry of this order, it would be effective for the drilling of a long lateral horizontal well so that you could go in and apply for an APD and go drill that. Is that your testimony?
Correct.
But for the short laterals, verticals, directional wells existing on these requested DSUs, this order wouldn't be effective with respect to those wells until the first day of the month following first production.
Correct.
Okay. In addition to establishing the requisite drilling units, approval of this RAA will allow you additional operational flexibility with respect to Indian mineral lands. Two-part question, if you don't mind. Are there Indian mineral lands at issue, and how does granting this RAA help manage those Indian mineral lands?
So first part, yes, there are Indian mineral lands in each of the 3 DSUs. And in our experience, when Indian minerals are involved, a spacing order not only facilitates, but is required for the BLM and/or BIA approval of a conforming communitization agreement, whether by guidelines or actual agency practice.
Thank you for that. Turning now to Exhibit E. This is a BLM plat showing the sections at issue. Could you walk the board through this and highlight anything that they need to be aware of?
Yeah, so the plat here is really to just demonstrate the partial sections that were referenced at the beginning here. So as you note, sections 25 and 36 in Township 4 South, 3 West, and sections 29 and 30 in Township 4 South, 2 West are partial sections, each comprised of small lots. Due to the USM-SLM border, the lands to the south are part of the Greater Monument Butte Unit. To ensure the partial sections are not orphaned and left undeveloped, OVENIV is requesting the inclusion of these parcel sections into the requested units as follows.
Okay. I'm assuming, would you mind going through the inclusion of the units? I'm assuming fairly straightforward. 17 and 20 would be a standard 1280. You're seeking the inclusion
Correct.
of section 29 in that. Can you walk through what that is?
Correct. So as we've discussed, the request is for stand-up DSUs, so therefore section 29 would be included with the requested drilling unit for section 17 and 20. Section 30 lands would be included in the requested drilling unit comprised of 18 and 19. And section 25 and 36 lands would be included in the requested drilling unit comprised of sections 13 and 24, Township 4 South, 3 West.
Okay. Thank you for that. Moving on to what is a fairly self-explanatory slide. This exhibit demonstrates that OVENIV is the majority working interest owner in each of the requested drilling units today. Will you please take a minute to just kind of address the last column, the UMI partner working interest and the estimated OVV working interest, kind of where those numbers come from and why it's estimated at this point in time?
Sure. So they're estimates for 2 reasons. We haven't finalized a drilling title opinion for all of these DSUs, so they're representative of the acreage we believe we own within the requested drilling unit. And they're further estimates because we have yet to actually ballot or propose these wells or any of these wells to the unleased mineral owners or any other working interest owners within the requested DSUs.
Okay, so you provided notice based on your internal production records and checking those against Duchesne, BIA, BLM, realty records. And when you say you haven't finalized a drilling opinion yet, that's a separate document that provides updated ownership for the new allocation of the long lateral well. Is that fair?
Yeah, that's correct.
Okay. Turning to Exhibit G, Let me just, would you please just reference for the board rough percentages Ovintiv owns in each of these requested DSUs?
I can't really make out the slide on the screen here, but my recollection, there we go. Thank you. We are between 85 and 3/4% to 89.7% in these DSUs.
Okay, thank you for that. Exhibit G. This depicts lands nearby the requested lands and has spacing orders identified. Can you please walk the board through what these different colors mean?
Sure. So DSUs, these are the DSUs requested today. They're shown in red as they've been on all the previous slides. The other colors show the other orders that have been referenced in the RAA. The blue is obviously the 139, 134 order. The pink is the 139, 150 order. The dark blue is the 130-09 order. The black is the 130-10 order. The green is the 600-02 order. And the brown is the 600-03 order.
Perfect. Are these units all operated, are the majority of these units operated by Ovintiv?
Yes, that's correct.
And how are they spaced under these orders? Are they spaced with overlapping? Or are they spaced similarly to the request here today before the board?
They are all spaced similarly to the request here today, being for conversion.
Okay, so they're all spaced for long lateral horizontal development from the lower Green River Wasatch. Is that true?
That's correct.
Okay. Final exhibit for you, Mr. Lair. Exhibit H. It's titled Notice Area. Will you please walk through this and kind of help the board, orient the board as to what notice was provided? First within the requested DSUs, the red hatched areas you said. What notice did you provide and to whom?
Sure. So as regarding the red hatch DSUs, all production interest owners were sent a copy of the request.
Okay. And outside the requested DSUs? Well, let me back up. In the red hatched areas, when you say all production owners, will you kind of expand on that a little bit? That means what parties or?
Sure. Anyone owning an interest within those DSUs was given notice of this request.
Fair to say anyone on your pay decks?
Correct.
Okay. And as for the red, pink shaded area that surrounds the requested DSUs today, who received notice in those areas, and how did you come up with those names and addresses?
So, because we've requested reduced setbacks on the north side of the requested DSUs, we noticed all working interest and unleased mineral interest owners in the established drilling units and the adjacent unspaced quarter sections as shown in that buffer area. Okay. And those parties were determined via a check of our internal records, as we talked about PAYDEX, as well as through the records of Duchesne County and the BIA.
Okay. So regardless of and I think you mentioned this, but maybe not, Ovintiv operates everything north of the Meridian line in this pink area. Is that a fair take from your testimony? Yeah.
Yes, that's correct.
And does Ovintiv operate below the Meridian line?
Formerly we did. At this point, no.
Okay. So, and how did you may have already mentioned this, and I apologize. How did you come up with the addresses and names for those folks that you noticed and as listed on the certificates of mailing on file in this cause?
Yeah, so we utilized our own internal records as well as checking the records within Duchesne County and the relevant records with the BIA.
Okay. Thank you for that. Does Oventive employ a contract land agent?
Correct. And thank you for that clarification. That work was done by our land broker, Lone Wolf Energy.
But it was done obviously under supervision.
Correct.
Okay. Now, kind of a last question, more of a housekeeping item, not necessarily exhibit related. Oventive is currently subject under the spacing orders identified on Exhibit G, is currently subject to a certification process in a couple different ways. Can you walk the board through what that looks like?
Sure. So currently, Oventive certifies to the division that the horizontal wellbores will be cemented and cased to the productive intervals within the established setbacks. Further, we also certified to division that we have obtained all requisite surface and subsurface consents / authorizations for off drilling unit surface hole locations to drill through to the drilling unit boundary when applicable.
Okay, and if I can rephrase that as a simpler question, you're going to certify that you've complied with the setbacks in the spacing order, number one, and number two, you're going to certify that you've gotten permission to put the surface location off lease. Is that fair?
That's correct.
Okay. And does your request before the board today in this cause call for the same certification process?
Yes, it does.
Okay. With that, I don't have any further questions for Mr. Lair unless the division does.
I do have a few questions. Thank you.
Please proceed.
Mr. Lair, the request for agency action is requesting that the 139-150 order be partially vacated, I believe. And part, is the partial vacating of that order just dealing with the setbacks? Is that what
I believe the partial vacation is the 26601 and the 26602. That's okay. I think those are force poolings related to the two wells regarding the recoupment.
Correct.
Waiver of that. So
Thank you. I was just seeking clarification on exactly what is being sought to be vacated, since we're keeping part of the order in place. And I'm sorry, can you summarize that one more time, since I...
yeah, no problem. I should have made it a little clearer, and I think the request did a good job. It's probably just user error here on my fault. The 26601 and 26602 orders are the force pooling orders related to the issue of recoupment that was mentioned in Mr. Lair's testimony. Lawrence Scott Noble was pooled by this board, and there is still money that he is owed for those production costs. Oventive is seeking to partially vacate those orders, not vacate the pooling order, but vacate the recoupment that they're still entitled to. And I believe that's what the vacation is limited to.
Okay, I was confused, thank you, that is very helpful. And so it sounds like with the partial vacating of that order, the recoupment will be, the waiver of the recoupment will be effective as of the board order. Okay.
That is my understanding, correct. Mr. Lair, is that your understanding as well?
I think to kind of clarify that, I believe that the recoupment will be forgiven when the conversion's effective. And as I previously testified, as to the existing wells, the conversion date becomes effective the first day of the month after first production of the long lateral horizontal.
That's a really important clarification. Thank you.
Okay. Yeah, it's weird. Okay. Also, do you mind showing Exhibit F? Thank you. This is that spreadsheet portion that discusses the ownership or the working interest going forward. On that second column, the UMI-partner working interest column, do you have an estimate of how much of that of those numbers are actually unleased at this point?
I don't. If I had to guess, it would be a very small subset of that, probably, less than half.
Okay. And would I be wrong if I assumed that those unleased interest owners are going to be dealt with in a pooling matter if you're unable to lease those?
That's correct.
Okay. No further questions. Okay. Thank you.
Board, any questions for this witness? Seeing no, yes. Mr. Moon.
Yeah, question on the south setback of 330, is that just because it's up against the meridian line, or is that a geologic, or, are there reasons that you're not comfortable with going to a lower number?
I'd like to defer this question to Kendall as part of his testimony. I think we're going to address it more succinctly with the exhibits to come.
Okay. Why don't I wait on all my questions till then?
Thank you.
I have a question on F.
Yes.
Can we go back to that Exhibit F again? And when you're giving your guess there, do you mean it's less than 0.5%, or is it less than the 10% that's in that final column on the right? Which would be about
thank you for the clarification. Sorry, I mean to say that it's half of the value reflected there. So
roughly half.
Likely 5% or less.
Okay,
Yes,
thank you.
Any other questions from the board? Seeing none, logistical question, Mr. Mayo. Before we go to the next witness, perhaps we should break for lunch.
It's entirely the board's discretion. If you guys are comfortable witnesses hanging on, it's entirely up to the board.
Board,
I anticipate, for what it's worth, about 25 minutes tops left. So
total for both witnesses?
I believe so. Josh and Kendall, will you be on your best behavior? Okay.
In that case, perhaps we should proceed and just go hungry.
We'll try and move.
proceed.
We'll try and move as quickly and efficiently as possible. Next witness, Mr. Reamer. If you'd raise your hand and identify yourself for the record, spell your name as well, if you could.
Yes, my name is Josh Reamer, Josh. The last name is Reamer, Reamer. Business address is 4 Waterway Square, The Woodlands, Texas, 77380. And my current position is the Geoscience Manager of Development of the Rocky Mountain area and have responsibility over the lands at issue today.
Okay, thank you for that. I'm going to show you what we've submitted as exhibits I through L. Exhibit I, J, K, and L. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or under your direction or supervision?
Yes, they were.
Okay. Exhibit I, what the board usually sees and hears referred to as the type log. Would you mind going through and pointing out what's relevant about this or necessary for the board to know in deciding this matter?
Absolutely. Yeah, Exhibit I is the field type log. It shows the Shell Brotherson 1-11B4 well. This slide shows the stratigraphic definition of the Lower Green River Wasatch Transitional Formation, and it comes from orders 139, 134, and 139, 150.
Okay. Is there anything anything that the board or division needs to know about the two different columns relevant to this, about what they show or what this summarizes? Is that something that you can address in a later exhibit better?
No, basically what the type log shows is a gamma ray log on the left-hand side and the resistivity log on the right-hand side. Typically, we use these in correlation, and it just basically shows the correlative formations on there as well, just to get everyone zoned into what we're talking about.
Okay. And let me go back here. These are highlighted in green from the Douglas Creek to the TF 1.9, not sure if I got that right. It's small on my screen as well. Does that
13.
13? Thank you. Does that correlate with the green on here? Jumping ahead to the next slide.
Yes, it does. It basically is highlighting the 5 primary intervals that we develop.
Okay. So for Exhibit J, please continue. Primary intervals and other potential intervals, et cetera.
Yeah, Exhibit J shows a log of the Willis Moon #1 well. It's west of the area at issue today. It basically shows the correlative log of our primary targeted intervals for long lateral wells. And again, as I said, it's to the west of the area that we're talking about today. It shows the 5 primary targets as well as 3 exploratory targets.
Okay. Exhibit K. Stratigraphic cross-section. Would you mind explaining briefly to the board what this shows and how it supports the request?
Sure. Exhibit K is a cross-section from west to east through the area of interest. It reflects uniformity throughout the area, and it also highlights that the Lower Green River Wasatch transitional formations constitute one common source of supply in the area, and is consistent with the board's designation of those formations as one pool throughout the Uinta Basin.
Okay. And it looks like one of the wells is within the requested DSUs. Is that?
That is correct.
Okay. Finally, Exhibit L, interpreted maximum stress direction.
That's right. So Exhibit L shows the interpreted principal horizontal stress direction. On this map, you will see some Rose diagrams and some arrows that indicate those observed stress indicators. Typically, these wells come from FMI logs or formation microimager logs. And basically what this shows for the application lands, you see an average fracture orientation of north 78 degrees west throughout this area. In this orientation, an angle supports stand-up north to south drilling unit orientations.
Okay. And based on exhibits I through L collectively in your testimony here today, I'm going to ask you a couple questions. I'd like to remind the board that Mr. Reamer is admitted as an expert in this cause. In your expert opinion, is the Lower Green River Wasatch a good target for long lateral horizontal drilling in this area?
Yes, it is.
Okay. In your expert opinion, does the fracture orientation that you just described under the subject lands dictate the drilling unit orientation?
Yes, it does.
Okay. And it supports, I'm assuming, stand-up orientation chosen here?
Yes, it does.
In your expert opinion, does the Lower Green River Wasatch constitute one common source of supply?
Yes.
And finally, does the request before the board promote the greatest possible recovery of resources, prevent waste, and protect correlative rights in your expert opinion?
Yes, it does.
Okay. With that, I have no further questions for Mr. Reamer, absent division or board.
Division, any questions for this witness?
No questions, thank you.
Board, any questions for this witness? Seeing none,
Yeah.
Mr. Moon.
So do you have one more witness, or is that?
Next up is the reservoir witness. If you'd like, we can do that, and then,
Yeah,
and
we'll
then
wait. and then-
anyone can answer.
Yeah, they can all answer.
Perfect.
Back to you, Mr. Mayor.
Thank
Good
you.
enough.
Moving on to our final witness, Mr. Kendall Brown. There you go. Thank you, Kendall. I'm going to show you first of all, if you wouldn't mind stating your name and spelling it and your business address for the record.
Yeah, absolutely. So my name is Kendall Brown. That's KENDALLBROWN. And business address is 4 Waterway, Suite 100, The Woodlands, Texas, 77380.
Okay. And your current position with Oventive?
I am currently the reservoir engineering manager with the responsibilities over Oventive's assets in the Uinta Basin.
Okay. I'm going to show you briefly exhibits M through P that we've submitted. Exhibit M, Exhibit N, Exhibit O, and Exhibit P. Do you recognize these exhibits?
Yes.
And were they prepared by you or under your direction or supervision?
Yes.
Exhibits M and N seem best talked to together, so I'm going to flip back and forth between them as you direct me, Mr. Brown. But if you wouldn't mind kind of walking the board through Exhibit M, what it shows, how it supports the request, and Exhibit N, and just holler at me if you need me to flip between.
Absolutely. So Exhibit M is a bird's eye view of Oventive's request that reflects the 100-foot setbacks to the north and 330-foot setbacks to the south. In the red is an example of a horizontal long lateral drilled in this unit. You can see in blue is expectations of our fracture half lengths, which I'll get into further in Exhibit N. As Mr. Reamer testified to, we do expect a 78-degree inclination on fracture orientation, which is described in the exhibit here. We have annotated as well into this exhibit to show estimates of drainage radiuses that are going to be occurring on both the very end tips of these laterals, showing that we can minimize waste while protecting correlative rights of surrounding owners. More details are on that in Exhibit N, if we'd like to go ahead and flip to Exhibit N. Exhibit N describes a much more transparent way that Oventive has changed our exhibits to show Hales and Evers correlation of elliptical fracture drainage. The assumptions are shown in the table to the left of our reservoir parameters. Oventive does have PVT data directly east of these lands that we're directly using to give a good idea of the reservoir fluids we anticipate in this particular area. The table on the right is our calculations of the elliptical drainage through varying time steps. This time steps is shown to go out to a 10-year time step. And the number that I'd like to call the board's attention to is the column that's labeled B. This is our minor axis drainage radius, which is the distance we expect to be parallel from our fractures, which within the setbacks we have would be very minimal, if any, drainage across the lease line, thus protecting the correlative rights of the neighboring DSUs as well as minimizing the waste.
Okay. Thank you for that. Exhibit O. There's one typo that I missed when we submitted these exhibits, and I'd like to call it out to the board's attention. It's the same mistake I keep making here. EUR per 1,280 acres is what's typed in this exhibit. Obviously, these exhibits are fairly standardized. But I'm going to ask you, Mr. Brown, before we start, the numbers in that column, do those reflect an EUR based on 1,280 acres or based on the 755 acres that the rest of these columns present?
Yes, all of the numbers represented in the table represent a 1,755 acre unit size, which is about the average of these three units in this hearing.
Essentially, if we took out 1,280 acres in that title, it's accurate and accurately reflects what's requested today.
That is correct. It is just the EUR.
Okay, thank you. With that, I'll let you walk this through this with the board, if you would.
Yep. So pursuant with our request for agency action, shown here is the petrophysical properties of each of the formations as well as the EUR, which is the estimated ultimate recovery that Oventive would expect to get from these wells. We have requested 8 long lateral wells within each bench. You can see the recovery factors there to the far right. That would be from each of these benches. With the request of 40 long laterals, that would result in a 7.89% recovery factor from the unit described here, which based on our experience and industry experience is a reasonable recovery factor to expect from these types of formations.
Okay, and this bottom just deals with the directional or vertical wells also authorized under this order or previously drilled. Is that right?
That is correct. So in the bottom is the addition of vertical wells that could increase that recovery factor up to 8.7%, which vertical wells obviously do exist already in this unit.
Okay. Thank you for that. Exhibit P, final exhibit for you, if you would. Just if you could discuss kind of the economics of this and help the board understand what each column means.
So absolutely. So one of the key benefits of going to long laterals is that we can reduce waste and protect correlative rights. What this allows us to do is increase the economic benefit of all participating partners in the wells, as well as increases the royalty and tax revenue for all owners as well. So what you'll see in this is a comparison of a 12,500 foot lateral to a 12,730 foot lateral. So again, we would be gaining that 230 feet on the northern side. So this is a 2% increase into the lateral length of this particular well. What we would see then in our expectation is directly a 2% increase into the recoverable hydrocarbons of that well. However, there is not a 2% increase to the well cost of that well. And the reason really that is because every well, regardless of lateral length, we have to drill the vertical portion of that well just to get to depth. And we also have fixed costs on surface for our pads and our facilities. So this allows us to have a lower dollar per lateral foot cost, which increases what you can see there in the bottom rows is the rate of return. It increases the return of investment. It decreases the payout of those wells. And like I spoke to previously, it increases the revenue for the royalty owners as well as severance tax that's payable to the state and tribe.
Okay. I appreciate that. Thank you very much. I'm going to ask you a couple questions, again, as in your expert opinion, if you would. Are up to 40 long lateral horizontal wells and the 8 requested short lateral vertical directional wells necessary to fully develop the lands at issue here today?
Yes.
Okay. And one final question. In your expert opinion, do the requested setbacks and the conversion process requested here today protect against adverse draining and waste, maximize resource recovery, and protect correlative rights?
Yes, they do.
Okay. Thank you for that. With that, I have no further questions for Mr. Brown as well.
Division, any questions for this witness?
No questions, thank you.
Board, any questions for this witness? Yes.
Sure, I'd like to go back to Exhibit M, if you could, please.
Happily.
And it wasn't clear to me why the 330-foot setback on the south end is appropriate versus the 100-foot setback on the north end. So could we revisit that again? Because it appears to me there's considerable amount of waste there. But maybe
so on Exhibit M, maybe the bird's eye view, that's a little easier to describe this.
Kendall, that's you, right?
Yes,
Okay,
I'll address that question.
Thanks.
Yes, this is Kendall speaking. So on Exhibit M, on the bird's eye view, you can see the little bit of difference between the north and south setback. So on the southern side, we are butting up against the GMBU. That is at a 15-degree angle. That plays counter to our fracture orientation that Mr. Reamer spoke to. So the amount of setback required there does vary versus a directly east-west setback. The other piece I'd like to touch on as well is these laterals that Ovintiv is planning here would be the longest laterals that we've ever drilled in the basin. This is fairly standard practice to drill up to 3-mile-long laterals in other basins that Ovintiv operates in. So we don't have the extreme certainty in achieving the long laterals and the costs associated with doing that. And for those reasons, we are currently not requesting to reduce the 330-foot setback, but what I want to leave the board with is, as we're able to drill some of these extended reach laterals greater than a 1,280-foot unit, I do anticipate Ovintiv coming back to the board to request potentially not 100-foot setbacks on here due to the angle I just spoke to, but a further setback reductions with our increased drilling certainty of these long laterals.
It's a technically complicated, something Ovintiv has experience with drilling these larger than 1,280 acre units, but to essentially walk before you run, extending the setbacks on the north but not on the south is a way to both deal with the setback issue and the the incline of the Greater Monument Butte or the Meridian Line, and to essentially make sure that you're not biting off more than you can chew. Is that?
That's fair.
Okay. Do you have an anticipated total depth of any of these wells, or an estimated, and how that would compare with a typical 1280? And I hate to put you on the spot, so if you don't.
I do not have that number off the top of my head currently, but I think the one thing to obviously mention for the total depth is, depending on how far east and west in these particular units, it could span up to an additional 5,000 feet from nearby offsetting wells, as we're bringing in a third section into these units on the far western side.
Okay.
Did you have another?
Any follow-up?
No, I'm just thinking about it, that's all.
I could see the smoke coming out.
So would you anticipate sometime in the future you're going to ask to, like, the second or third well that you drill out here, that you might be trying to use up a bit more of that setback?
I would absolutely anticipate this. Drilling these up to 3 mile long laterals is an initiative that Oventive has taken in other basins that we operate in. It's a very commercial way to operate, and it's also it helps out all participants, including the royalty owners. So I absolutely expect Oventive to continue to pursue the shorter setbacks that we deem necessary in order to reduce waste and prevent correlative rights, or protect the correlative rights rather in the future. It's just we have to do a bit of get a couple wells in the ground to understand exactly our drilling performance for these longer laterals.
Okay, go ahead.
Mr. Moon.
So, yeah, speaking as a mineral owner, we really appreciate what Oventive is doing here. This is a good opportunity to reach out further and reach some units that wouldn't, that could be stranded. But I would just like to press you further and just suggest, jumping from 100 feet clear up to 330 feet, because 330 feet was the standard, and now we're going to 100. I would just encourage you, to look at as you go forward, maybe setting some sort of a buffer from your frac reach versus a standard 100 versus 330 feet, so that we have kind of a standard buffer between where your frac's going to reach versus the section line. Just think about that, because it does appear like has just been said, there's quite a bit of waste there. So did the Meridian line come into play there, or that wasn't really the issue? It was more, did the Meridian line come into play in deciding the 330?
So I would say it's a part of the decision making. The Meridian line does impact our drainage estimates just due to the fact that the Meridian line is not perfectly east-west. It does play counter to the angle that Mr. Reamer testified to on our stress orientation here. So we do need to consider the angle of the Meridian line in order to ensure the protection of correlative rights. But that is just a piece of it. There is the drilling concern of the longer laterals as well.
Okay. What is the longest lateral or as far as Oventive? Do you have any others longer than 2 miles at this point?
To my knowledge, our longest is 11,000 feet. So it's just over two miles. But I will say that in our Permian operations, we routinely drill 3 mile long laterals.
Okay. And based on the geology here, you don't anticipate any big issues versus your Permian 3 mile horizontals?
If you don't mind, this is Josh Reamer. I'll address that. You know, it is shallower here, so from a drilling perspective, we will be fighting the shallow nature of, if you will. We do think it is achievable, but that's one thing to consider of how well we can push weight on pipe. Second thing to consider too, in the southern part, we do have the Duchesne fault zone that we want to perpendicularly intersect, and I've testified in front of this board about trying to do that and being efficient in that manner. So we do have some other things we're going to have to be working with and thinking about, but we do think it's achievable to do it. So just follow up on Mr. Brown's points. I really think we just wanted to take a conservative stance, drilling so close to the meridian line and pushing the length here. But we do want to come back, even maybe after we drill these first few wells, and probably extend it if we are successful. So please don't think that we're walking away from this content with the 330 on the south. No, we're not. We're just trying to take a conservative approach here.
Good, thank you.
Any other questions from the board? Yes, Mr. Church.
Has Oventive previously intersected the Duchesne fault zone with a long lateral?
Yes, sir, we have. We've done that in our Philip Alice DSUs to the west of this location.
Did that cause any problems with lost circulation or any?
I'm sorry. We did not see any lost circulations once we crossed that feature.
Okay, thank you.
You're welcome.
Mr. Moon?
So do you anticipate any more vertical wells, a scenario where you would have vertical wells after you've drilled horizontal?
We would like to retain the ability to do that depending on our horizontal wells' ability to drain the resource and achieve the recovery factors that I testified to. There can be a need to drill subsequent vertical wells that we would like to have that ability to do so if it's needed after the horizontal development.
Okay.
Just to clarify, under the spacing requested, it looks like, just eyeballing, a couple of the DSUs are filled up under the requested well, so it probably would require a later modification based on results.
Any other questions from the board? Back to you, Mr. Mayo.
Thank you, Mr. Chairman. I won't belabor this long. First, I'd like to move for admission of Exhibits A through P and the exhibits to the request for agency action to the extent those are necessary to be admitted.
Yes, so admitted.
Okay. And I'd like to confirm administrative notice of Mr. Jensen's testimony from the 139-134 matter regarding conversion and its the way it deals with correlative rights.
Agreed.
Okay.
So confirmed.
Okay. And finally, I'd just like to point out that all the statutory and regulatory requirements for approval have been met. Oventive has demonstrated today that these lands are set up for and appropriate for long lateral horizontal development, that 40 wells, long lateral horizontal wells are required, and that at the time being a 100-foot north setback and a 330-foot south setback with 560-foot east-west setbacks on these stand-up drilling units is reasonable, is the most conservative approach to managing these DSUs, and prevents waste, promotes the greatest possible recovery of the resource, and protects correlative rights. And with that, I'd submit to the board.
Thank you, Division.
And I apologize. I'm wondering if we can have a brief 5-minute recess just so I can verify something with council and hopefully speed up the process for the division's presentation.
Yes.
Okay, thank you.
I neglected to say we're probably off the record then, but we're back on the record, or we already are on the record. So I apologize, but a couple of board members had a couple of follow-up questions, Mr. Mayo, if that's okay, and then we'll go to the division.
Not a problem.
Mr. Hanson or Mr. Walker?
Let's go back to Exhibit M again, if we could, please.
Sure. I don't know. Oh, there you go.
Okay. And what we're concerned about is that we don't want to leave a lot of waste on the south end. And also on this one here, you've got a very large setback on the, what would be the west side of this section. Now, would this be a depiction of one of the sections that's on the east or in the center section or that west DSU? Because really concerned that it wouldn't make any sense if it's somewhere along in the middle where you're leaving a setback like that on your own DSU. So could you talk to us a little bit more about what this Exhibit M represents?
No, that's a very good question, and I'm kind of glad you bring that up. So this would depict a western slot within any of the DSUs. You bring up a very good point around potentially being some waste on the western side there, and it is not in this particular RAA, but is Oventive's plan and others within the Uinta Basin's plans as well to pool both units in between to be able to drill wells directly down the lease line of two DSUs with split ownership there. That is not a part of this RAA, but that is the bigger objective, I would say, for industry in the Uinta Basin to prevent that exact waste that you're talking about.
So I would like to understand that certainly it's on the record then that you're going to come back and fill in these gaps sometime in the not too distant future, once you've gotten a little bit more drilling experience at these long laterals. Would that be valid?
Yeah, Oventive's expectation would be to try and, where it makes sense, drill lease line wells for a lot of the lands that we operate in.
Okay.
And I guess
Thank
maybe
you
to,
very much.
yeah, maybe to clarify, Kendall, I guess maybe your hesitation is there's no immediate plans Oventive has to come back in 6 months and request 2560s and or drill 2560s in these three DSUs. Is that where the hesitation comes from in your response?
Yes, we don't have immediate plans to do that within our budget expectations, but that is our development goal for the Uinta Basin as a whole.
And to kind of keep that development slot open, you need to keep these setbacks where they are laterally, east-west from the wellbore, so you have that optionality to come back later and add in section line wells. Is that right?
Correct.
Okay.
So it's somewhere in your plan of depletion, but could potentially be down the road.
Yes, that's fair.
Mr. Moon?
Sorry, just to follow up on that, it's just big picture. So you're 560 on either side of the section line. One section line well would not effectively drain that, correct? Would you have multiple ones, like offset from the section line, or?
That is a good question, and I would say it would depend a bit on the area, but it would be more so thought of around the formation specific of a well. You could have multiple wells that we would drill on a lease line targeting separate formations.
Okay, it's just everything between that 560 and 560 would be considered a section line well. It doesn't have to be on the section line, correct?
That's right. And from a non-Oventive perspective, but just the way it's going perspective, it seems like there are kind of two different schools of thought. Shrink the 1280 setbacks, the lateral setbacks, as close as you can to the section line, and then stack the section line wells essentially on top of each other, directly centered on the section line. The other school of thought seems to be work within the existing 560 setbacks because there are so many horizontal wells being drilled out there that complicate it, and then use that 560 to 560 as a 2560 drilling area.
Any other questions from the board? Yes.
I wanted to ask about the western DSU, section 30, with the setbacks that you have right now. Have you shown that you will be able to actually even drain resource out of section 30? Or demonstrated that your well will even be able to penetrate into that section?
And I think you mean section 36, this little nubbin down here at the bottom.
Excuse me, I thought that was 36.
That's okay. It's,
I mean, I understand, you know, if it gets orphaned, but I don't know that the current relief you're asking for even could justify draining from that section right now.
do you understand the question, Kendall and Josh, Jordan?
Yes, you're specifying the small sliver section in the very southwest of the 3 units. Is that correct?
That's correct. Yes, with the setbacks that you're asking for now, have you shown that you will actually be draining that with a well that's drilled under the current request?
I think where our drilling request is at right now, that section is pulled into our units, and we probably will drain some of it, but to 100% effectively drain that sliver, given the meridian line, given our fracture orientation, is going to be a challenge almost regardless without going over the meridian line there and encroaching on correlative rights on others.
Well, and especially with the setback that you have on the southern boundary as you're asking now.
Yes, sir. And the only point of clarification, this is Jordan speaking. You know, we did look at that when we submitted the request, and what I would say is that the length of that unit is, or that section is longer than 330. So, you know, we've spoken to the you know,
Jordan, you mean
drilling,
this? You mean this like north-south length, the height of it? So there could be a perf technically on the western slot well,
correct,
that does get into that little.
Correct. So what I'm saying is that the setback will not eliminate that from being able to be penetrated by a well and also produced from it. So.
Thank you.
Any other questions? I know it's exciting because it's not a rectangle. Okay, division.
Thank you, and I will be quick. I know we're running short on time. The division has reviewed this request. After the division's review, it appears that Ventive has met the requirements under statute and rule to move forward with this conversion and spacing, and so the division would generally recommend that the board approve this request with one small asterisk, two small asterisks. First, that the final order include the representation that the recoupment for Mr. Noble is going to be waived as part, and second, as council is discussing the language of the proposed order, the division still has a question whether it should be a partially vacating Order 266 or whether it should be a modification of 266. And that is something that Mr. McDonald and I can figure out how legally best to do that. So I would just request that we modify, or that you approve the request that we are modifying or partially vacating Order 266. So just we can be clear in case we change that.
And just to clarify, that recoupment was effective the first day of the month after first production?
That's correct.
Yeah, and I think that kind of goes to the vacating as well. So we just want to make sure that it's clear in the order exactly what's being done and when.
And to be clear, this is As Ms. Harris said, she's a trained linguist. I'm a lawyer, so this is mostly just fighting over words.
Yes.
But
This
we'll
is-
get it sorted out in the order, as I think. That,
This is a word fight, not a substance fight. So,
Okay, board, do we need to deliberate this, or are we prepared to make a motion consistent with what we just heard? Okay, I will await a motion.
Okay, I'll make the motion that we approve the request for agency action by Oventive, subject to the two conditions expressed by the Division of Oil, Gas, and Mining.
I hear a second. All those in favor, except for Mr. Moon, say aye.
Aye.
That was unanimous, and it should be noted that Mr. Moon did not vote. Thank you very much. Mr. Mayo, will you prepare the order in consultation with the division?
I'm happy to. If it pleases the board, Mr. McDonald may do so in my stead, but I'm happy to do it if he doesn't.
See, everything's complicated.
Is every-
Yes, that
This
is
day
appropriate.
will live in infamy, Mr. Borden.
Thank you. I think that concludes this matter. I think we should just work through lunch. No, that's a joke. Let's take a recess for lunch, and we will reconvene in exactly, perhaps let's do it in 55 minutes at 1:30. Is that okay? All right, we are off the record. Okay, we are ready to go back online. Yes, if we can.
We are live.
We are back on the record. Two more items today. The first, number 6, docket number 2022-028, cause number RMNRL-2022-01, in the matter of formal rulemaking to amend the mineral program rules to conform annual reporting deadlines to the Utah Mine Land Reclamation Act. I do not call for appearance of counsel. I believe I will give the time to the division.
All right, thank you. I'm Natasha Baliff. I'm the Legislative and Policy Coordinator for the division. And I'm bringing two separate, I know they're two different numbers, but both of these I will be asking the board to grant formal rulemaking, to start the process of formal rulemaking. So this first one is an annual report deadline. Super simple. This is a 2-slide presentation. So right now it currently says on or before November 30th of each year, an operator will submit a mineral exploration progress report. The only change we're making is changing it from November 30th to December 31st. I know that there has been a comment made about making it say the end of the year, but we think that with it saying on or before December 31st, an operator could submit it even on November 30th if they wanted to keep that deadline. But again, this is the only change that's being made. It should be a fairly simple process. We just need to have permission to start the formal process.
Board members, any questions or comments? Yes.
I'm sorry, this may be a really silly question, but if you submit it before the deadline, will it be complete if you haven't, for example, recorded certain water encountered or drill hole plugging activities? Would you then put that in your next year's report?
I am not 100% sure, but I'm pretty sure that we could be flexible in that manner. The reason we're changing this date is because right now everything else is due on December 31st. Fees and other small mine and large mine operation reports. So as we're transitioning into the new date, if someone still has it in November, we're not going to go write a violation or tell them they're doing something wrong. We'll work with them to figure it out and get that information in a timely manner.
Yeah, hearing my question and your answer afterwards makes me feel kind of foolish for asking it, so thanks.
Okay, is that the end of your presentation on this one?
Yeah, that's it.
Okay. Do we need to go into deliberations? I would. I assume no. In that case, I believe a motion is in order. Is that correct? And that would be to start formal rulemaking on this issue, huh?
Yes.
I can make the motion that the board approve the division's request to enter into formal rulemaking in this matter.
Second. All those in favor say aye.
Aye.
Aye. Let the vote show, or let the record show that was unanimous. Any further discussion on this from the board? Okay. I guess we can move on to item 7, docket number 2022-029, cause number RMNRL 2022-02, in the matter of formal rulemaking to establish the Minerals Exploration Tax Credit Program.
Yes. Do I need to state my name again? Okay. Again, I'm Natasha Baliff, the Legislative and Policy Coordinator for the division. So this last legislative session, Senate Bill 250 passed, and that created the mineral exploration tax credit. This rule will describe and clarify the process, who is eligible, what to expect after expenses are either approved or denied, the reassignment of the credit, and then the division submitting it to the State Tax Commission. So kind of just an overview of what the language says. There is a form that the division will need to create that will include, I think, everything that you would expect from a form for this. So name, address, phone number, email address, taxpayer ID, the amount of the proposed tax credit, the proof of the certified expenditures, a description of where exploration took place, and then proof of each expenditure. Additionally, it does lay out the requirements of it. So you must be in the business of extracting minerals. You must be subject to severance tax and paying that severance tax. And you must provide proof of certified expenditures. Once the division gets that, we will either approve or deny them, and we must give written reason for why it was denied and then allow for any correction of deficiencies. And then just kind of a note that was in there was no certificate will be given if expenditures at the same mine exceed $20 million. You can reassign the credit, so the claimant would need to give written certification saying that they will not claim the credit and then provide contact information for the person that they are assigning it to. And the division will annually submit an electronic list to the tax commission by June 30th, and that will include the names and identifying information, the approved amount, and then any reassignment information. And I believe that's it. So if you guys have any questions on that, sorry.
Mr. Moon.
So why can you reassign that credit? Just to anybody, any other operator? If you can't use it, you reassign it to somebody who can, and they pay you for it, or I don't know. I
don't think the statute was really clear into why you could. I'm not sure. I would have to. Do you remember the language with it?
I don't. John Rogers might. I think it. I don't think you can assign it to anyone. I think it's. It has to still be that for that operation.
Oh, okay.
And so if you.
Okay.
Yeah, if you change operators, someone else can claim that tax credit. And just something, this is similar to the workover tax credit in the oil and gas program, where they give us information, we look at it. But you have to have gone from exploration at a site to an operating mine, and you have to have already paid into the severance tax up to $20 million, and the maximum you can get in this credit is $20 million. So it's not, if you're out exploring and you never turn it into a mining operation, you do not qualify for this credit. It has to turn into a mining operation, be operating, and have paid at least $20 million into the severance tax fund before you can apply for this.
Any other questions or comments? Yep. Yes, Chris. Mr. Hanson. Or
Okay.
You'll be next, I swear.
Just wondering who in the division, I would assume it's in the minerals department, do you have somebody in that division trained to evaluate this information?
Well, like I said, this is similar to the oil and gas workover tax credit, so John Rogers might be the person looking at these because he looks at those. So,
congratulations.
He's a geologist, but he also has an MBA, and he's familiar with this type of financial information. And so, right now, if we get one, he would be the person assigned to look that over.
I'm sure he's well qualified. Thanks.
Mr. Church.
So is this tax credit, if it's an ongoing project, it's something that is filed annually, and you have to show that the expenditures are in that year, and then future expenditures in the next year?
They can file annually. The expenditure doesn't have to be in that year. It has to be, like I said, it has to go from, if you're doing exploration, you don't get the credit until you become an operating mine. So it would be for prior years, but you'd have to show all of that information and that you had spent up to that amount of, so the only reason it might go into multiple years would be if you're continuing to explore while you're operating and you haven't gotten up to $20 million yet, you may apply more than once.
Any more questions? Seeing none, have you completed your presentation?
Yes, I just need a motion from the board.
Okay, I assume we do not need to deliberate, but, all right, in that case, I would entertain a motion.
Okay, I'll make a motion to approve it as requested by the division.
Second.
All those in favor, say aye.
Aye.
Let the record show that is unanimous. Any final comments on this issue by the board before we move on? In that case, that was the last item for today. Is there a motion to adjourn the hearing?
I move that we adjourn.
All those in favor say aye.
Aye.
Aye. Yay, okay.
Thank you.